Good evening, everyone. Welcome to our weekly Wednesday webinar with the Property Law Alliance. Our apologies for being a bit late. We had some technical difficulties, but I hope everyone is doing well. And then welcome Bruno and Silna.
Hi, Marley.
Hi, Marley. Thank you.
How are you guys doing, Silna?
Good, thank you. Especially tonight, we have two of me. I promise I don't really have like split personality disorder. This is part of the technical difficulties that we're having.
Yes,
but both of me are very, very well. Thank you.
I'm glad to hear that. And Bruno, how are you doing?
I'm all right. Thanks for asking.
I'm so glad to hear that. All right, we have quite a few questions tonight. We have received one question that is a bit unclear from Mr. Shabalala. If you are watching now, if you mind maybe just submitting your question again, then we'll definitely discuss it. All right, so let's get started with the rest of our questions. Okay, the first one is, good evening. May I please ask some questions? I inherited my parents' property now, and there's people staying there without my consent. If I ask them to pay the rent so that I can pay the water bills, they say I should pay the bill because I say that it's my property. Please, good people, tell me what to do. I've been to legal aid for help, but they say they're going to evict only one person on top of 28 shacks. When I'm in the property, they threaten to kill me, swear at me. And now I'm staying with friends, but my parents left me a big property. Please tell me what to do. I can't just give up my place. So I don't know, Bruno, if you maybe want to get started on that one.
Sure. All right. So if we try simplify the question as much as possible, the reality over here is the inheritance doesn't really play, or there's no consequence to this, because the bottom line is the client or the person is the owner of the property. So there doesn't seem to be a dispute insofar as the inheritance is concerned. So we're looking at an owner of the property that owns a property that happens to have certain squatters in it. So I mean, this goes back to the number of episodes and talks that we've done where we've said, unfortunately, you do need to follow due process, and you would need to start off by issuing eviction proceedings. Typically, one would always try and negotiate, but I mean, that doesn't seem to be plausible at the moment. You try to send off letters of demand to express that the occupiers of the property appear to be there unlawfully. So now it actually comes down to a question of, well, let's put it like this. We've run through the eviction process quite a bit in the past. So, I mean, most of our viewers would know what the process is. It's a letter of demand followed by an application. It's something that we call the Section 4.2 is followed after that, and we get a date for hearing. I think what makes this particular question different from some of the other questions that we've received is it's not simply a question of a lease agreement that we have to cancel, make sure that the tenant is in unlawful occupation, and continue the eviction process. Here, we might be looking at a small number or a large number of occupiers. And from the question, it's difficult to ascertain. If my understanding is correct, we're looking at about 28 unlawful occupiers. So this does make it slightly harder or slightly more complex eviction. This is typically the type of stuff that Greg also deals with quite often. And in cases like this, what you find is, unfortunately, there's more consideration that the court has to place on the scenarios or the status or the position of the people that are living on the property. So unfortunately, that does make it slightly complicated. Things that you could look into sometimes to fast track evictions like this, and I've done it a couple of times, but only in very extreme circumstances, is if there's an actual property on if there's an actual building on this property and it is being substantially damaged to the point where you may actually suffer substantial material damage or harm. There are ways you can try to urgent eviction applications, or just try to change the status quo to place security guards on the property or something like that. But short of extreme circumstances like that, you would have to probably start by engaging the occupiers, finding out why they're on the property. And once you determine this, try find all the information you can on them, including whether there's children, elderly people, households headed by women, etc. And once you have this information, you approach the court, give the court the facts, and you push for an eviction order.
Perfect. Silna, do you have anything to add to that?
No, I think Bruno, you covered everything there, and I think there's so much. It's always so sad for me, especially when somebody, like in this case, inherits a property or buys a property on a sheriff's sale or something like that, and then eventually they end up with an eviction like that, that they didn't budget for, they didn't bargain for. We actually received an instruction today also on a sheriff auction, where I know it's going to be a majorly problematic eviction. The risks of executing the eviction order is similar to what I've seen in the past on a few evictions, where it's almost impossible to execute your eviction order, short from like seriously spending thousands and thousands of rands on security guards, private security companies, things like that. And it's very sad because I think we can see those evictions coming, and we know which evictions it will be that, where very often I find that owners sort of hold on and don't commence with eviction proceedings simply because they want to avoid the costs. And what happens then is the people stay there for longer. They start building like a bit of a community just in the property, and it makes an eviction even more difficult. So that's the 10 cents I'll throw in, just not to delay eviction, the commencement of the eviction, but also I know this property wasn't bought on a sheriff auction, but if you do buy from an auction or whatever, deceased estate, make sure you know what the circumstances are around the occupants, because as much as we can do any eviction, some evictions take longer than others, and some take really, really, really long. There's luckily not a lot of them, but if you are in a situation like that, it is tricky, and don't try to do anything other than just follow legal eviction proceedings.
Okay, perfect. Thank you so much for that. I think if we can maybe just quickly to the same question, get back to the fact that she says she asked them to pay the rent so that I can pay the water bills. So let's say the owner doesn't have any money to pay the water bills because he or she is not receiving any income or rental income. Is there interim relief that such a person can seek from court? I don't know, Silna, do you maybe want to answer that?
Yes, that's an excellent question on top of that. Thanks. I think something very important there is, first, I'm going to start with the problem, and I promise I'm going to get you an answer. So the starting point is, I get the question quite often from people saying, the landlord saying, I don't have money to pay for the electricity. Can I not just stop paying, something like that? The problem is, remember, as the owner of the property, you will always have a responsibility towards the municipality. Most of the bylaws doesn't allow electricity accounts, utility accounts to be with the occupants anymore. And especially, I mean, in this situation, it's not like you're going to approach these people that doesn't want to move out of the property and say, listen, let's put the account on your name. It's not going to happen. And anyway, the bylaws will not allow that. So what happens is, when an owner then doesn't pay, the problem is you remain liable for those payments. I appreciate that you're not the one using the utilities, but you're still liable towards the municipality. And yeah, I always use the example of a bonded property. If you have a non-paying occupant in your property and the property is bonded, you're not going to be able to call the bank and be like, hey, F&B, what's up? So the thing is, my tenant's not paying, so I'm not going to be paying my bond. Unfortunately, the landlord and the owner of the property can never be absolved from his obligation to pay for the utilities. So that's the problem. So don't try to not pay and hope they're going to disconnect because you don't pay. You're then going to be the one with the judgment against your name because you didn't pay. Yes, the electricity might be turned off, but then you're going to be responsible for all those disconnection charges as well. So that's not a good idea. So don't stop paying because you want it to be disconnected. In a case like this, excellent question, Marilee, where you're going to struggle, where an eviction is going to take a bit longer. So in a case where you have quite a number of people that might need alternative accommodation, so we might have to wait for municipal reports, things like that, or in a situation where a property was bought on a sheriff sale in execution, and there's a dispute surrounding the actual original sale. That could be a real problem that could delay an eviction. But to mitigate the owner's risk in a situation like that, to mitigate the damages for utility payments, there is a beautiful remedy in law. And that remedy is a utility disconnection application. So we do have the remedy and we do have the right to approach the High Court. We are bound to the High Court on this one. Match Court will not have proper jurisdiction on this. So we can approach the High Court. We can show to the court, we're not bringing a utility disconnection application instead of an eviction, because that's never allowed. We're bringing this utility disconnection application because there's no other way of mitigating this owner's damages other than disconnecting the utility supply. So what we normally pray for is, we say, and by pray, remember, that's what we say in law, that's what we mean by asking the court for. It's not like we're just sitting and praying and hoping for the best. Like what we normally ask the court for is, first off, that the occupants pay the full arrears and continue to pay on a monthly basis as the owner gets invoiced. And if they don't, that the sheriff of the court then be authorized to instruct a plumber and an electrician to disconnect the water and electricity supply, and then also an interdicting the people from reconnecting the utility supply. So there is a remedy like that, Marilee. Unfortunately, we have to go through the High Court, so it's not an overnight thing, but it's a quick, easy application, actually. You can obtain the order depending on the court you go to and depending on the role. So not Pretoria High Court. You can get an order like that in about 2 to 3 months. So if you know your eviction is going to drag on, and you can demonstrate to a court why you need to mitigate damages by disconnecting utility supply, you're probably going to be successful with an application like that. At SSLR, Bruno, I don't know if you've had the same experience, but I believe you do. At SSLR, we've been doing utility disconnection applications for the past 5 years. And funny story, I haven't received an opposition to anyone in 5 years. So for some reason, I think people think you can't oppose that or it won't happen. We've had great success with utility disconnection applications.
So from my side, my experiences have also been quite positive with a disconnection in landlord-tenant relationships, as well, obviously with the body corporates. With squatters, sometimes it does get a bit complicated, especially because of certain human rights issues and the dire circumstances behind it. So I have seen things like that sometimes hamper the process. But yeah, it is generally acceptable because the landlord shouldn't be expected to pay. So you can ask that the utilities be disconnected. What we've sometimes done is a shortcut, especially if clients don't have the funds or the energy to go to the High Court, is we've actually addressed the municipality and told the municipality that we're in a situation where we cannot afford to pay. As far as we're concerned, they should disconnect the power or limit the use of water to the property. Obviously, it doesn't play out like that. But basically what we say is from this point on, we're refusing to pay because we've given you notice that it should be disconnected. We're not utilizing it. So you know what? It's now the ball's in your court. Now, obviously, the municipalities never respond. But the reason why we send that letter out is, number one, it's not an act of spoliation. So we're not going there and disconnecting things ourselves. No one can blame us. Secondly, if you can actually persuade the municipality to disconnect, and the municipality gets that right and they disconnect it, yes, there might be a couple of charges to this, and you do still remain liable up to that point. But no one's saying that you send a letter and stop paying. Keep the money. Keep putting the money aside because it is going to be essential to pay the municipality. But if you can get them to disconnect and stop with some of the charges, it might save you in the long term, and you will still need to put money aside, but it will be a lot less money than if the power continues to be supplied. So it's just a little shortcut. Sometimes it works. It's the funniest thing. I've got clients who in 1 month they query and they have an actual query on an invoice and they don't pay, and the municipality switches them off within like a week. And I've got cases where like two years down the line, when we're doing an eviction, you still have the municipality struggling to disconnect and having the water and lights bill up to 200,000, 250,000. So it's madness. I don't understand how some people get disconnected so quickly and some don't. But if that kind of gains some kind of uniformity, you'll find that it would be a bit fair.
Exactly. We were in court today with an urgent application. Claire, one of our senior associates, water disconnection on an incorrect account. So they connected the wrong body corporate water, and we had to like bring an urgent application while the city knew they disconnected on the wrong body corporate. So I agree with you. Sometimes you never get disconnections and it runs into thousands and thousands of rands. And sometimes they disconnect on the incorrect account and you think, my Jana.
Yeah, it makes no sense.
My Jana is also one of my favorite legal terms.
I'm not even gonna try.
Yeah. All right, thank you so much for that. I think it is quite clear what the legal position is, so I think we definitely help this viewer. All right, so let's move on to the next question. So they ask, when will EAAB start taking action on agencies employing unqualified agents to do qualified agents' work? All right, so I don't know, Solna, do you want to get started on this one?
I thought it was Bruno's turn.
I don't want to.
Okay, I'll take it. I'll be nice.
Maybe the requirements of an agent.
So I'll answer the question first on why Bruno and I are bouncing the question between us. Because the answer is, unfortunately, we all would love to know the answer to that question. Was that diplomatic, Bruno? No,
yeah,
not
nice.
at all.
Well done. No, well
done. The truth is, I honestly hope that at some stage we get to a point where, yes, for hoping under the Property Practitioners Bill, the Property Practitioners Act and the Property Practitioners Council, we get to a point where property practitioners are properly regulated. And I say this with the necessary respect to the EAAB. The problem is, unfortunately, there are too many agents that aren't properly qualified and they are trading as agents. There are people that really just even aren't estate agents, and they are doing property deals that is 100% the work of an estate agent, but they don't have fidelity fund certificates and they're not allowed to do it. It is actually a criminal offense in terms of the Estate Agency Affairs Act. And yet it happens. But I think what's important to know is, if you know about a situation like that, to moan on somewhere isn't going to help. You need to report that to the Estate Agency Affairs Board. It's going to be a pain. And unfortunately, I wish it wasn't. I wish it was easy, quick and easy to report something to the EAAB. Unfortunately, you're going to have to follow up. And to follow up means you're going to call 5 times and the phone will be answered every 7th time. So it's going to be an absolute pain. But it's important that you do that. It's important to report people that are trading without fidelity fund certificates. I know SSLR is very often not very popular amongst agents, because if we receive an instruction from an agent and we get to the point where commission needs to be paid out on transfer, if I don't have a valid fidelity fund certificate, not at the day of payment of the commission, at the day of conclusion of the offer to purchase, I simply refuse to pay commission. I must say I've irritated quite a few people in the past, because I refuse to pay commission to an agent that doesn't have a valid fidelity fund certificate. And the truth is, unfortunately, and I put the ball in the agent's court, if you are in a position like that where you like to work with a conveyancer because they sort of cut corners here and there, remember they cut corners with other agents as well, and they pay commission to agents that doesn't have valid FFCs. And I'm not talking about fidelity fund certificates now where you struggle to issue. Obviously, you can then prove that. But an agent that isn't a registered agent, appreciate the conveyancers that refuse to pay commission and where somebody doesn't have a valid FFC. And if you know of a person that's trading without a valid FFC, report it to the EAAB. And yes, we're hoping under the Property Practitioners Council, things will look a little different.
So what's interesting, or just building on what you said, what I noticed is very interesting is if an agent under the current act acquires commission and they don't have a proper fidelity fund certificate and they actually acquire the commission, they get paid for it. Unfortunately, no one can actually claim it back from them. So the courts have found that once the ship has sailed, it's sailed. The money's been paid, it's been paid. So yes, it is a criminal offense, and yes, it can be reported. But I suppose the question is, the EAB needs to go after unregistered agents, but the EAB doesn't necessarily have jurisdiction over unregistered agents. So it's not as though they can discipline them. I mean, they can blacklist them for what it's worth, but that's pretty much where it stands. So it ends up being a criminal offense that actually needs to be enforced through the courts. Some form of interdict if a person wants to do it privately, or some form of criminal conduct. Insofar as the payment is concerned, unfortunately, if you can't stop it before payment is made, it's going to be difficult to claim back. What appears to be the case is under the Property Practitioners Act that changes, because now the person retains a claim for the commission. So if it happens that a seller pays commission out and then later realizes that the estate agent or property practitioner is not registered, they can go back and actually sue and acquire that money. So that's just a little interesting point, that as soon as there's going to be this regime change, it does actually afford a seller slightly more rights to claim commission back in cases like this.
Yeah, thanks for that. I think it's a very important thing for people to be aware of. And I think actually just a little practical tip. We must know I'm the practical one randomly at the end of every question. I think practically, remember, if you are a seller and you're mandating an agent, ask for the fidelity fund certificate. You are 100% within your rights to ask for that. As much as you're going to do due diligence on any transaction that you do due diligence on an estate agent before you instruct them. Obviously, it's easy if you stick to reputable agencies. The statistical chance of having a non-registered estate agent is less. But still, even if it's with a very well-known national agency, ask for the agent's fidelity fund certificate, bam, and your problem is solved.
Definitely. All right. Thank you for that. And then, all right, our next question. They ask, what is a digital signature? And when signing an OTP, can one scan and paste the initials and signature to an OTP and send via email? So I know, Silna, you have some interesting recent case law on that, but I think, Bruno, if you want to get started, then we can move over to the recent case.
No, absolutely.
All right.
So look, the position as it's always been is that digital signatures throughout our law are valid. You can enter into plenty of agreements where you can sign the contracts digitally, and there's a number of ways you can do this. I mean, typically a person would scan in a document, or now we've been using a lot of copy-paste signatures. We're on PDF, we simply put it in. I mean, we can even go so far as to say that the signature of your email constitutes a valid signature for the sake of actually concluding an agreement. There's even been cases regarding WhatsApps and agreements being concluded, provided that the parties had the intention of entering into an agreement. And that's an important concept, but it's not something that we necessarily need to touch on right now. So the reality is, if a person shows their intention by somehow marking an agreement on some kind of either written document or whatever the case is, it is valid. This applies to lease agreements. It applies to the majority of agreements. A couple of agreements, however, there's legislation that takes it one step further and regulates it. So, for example, with wills need to be signed in a certain way. So you guys need to be careful with this. Suretyship agreements, very similar. They need to be in writing. They can't be done verbally. So obviously, the deed of sale is the big one. Because the legislation requires, and I mean, it is a bit archaic. So I've always had this argument with the legislation in itself, with the wording, simply says in writing and signed by the parties. But this has been interpreted time and time again as being actually printed out. So like Silma mentioned earlier, like wet ink. Now, strictly speaking, on the wording of the act, one could still try and interpret it as allowing digital signatures. But the problem is, in practice, with the common law, the way that the judges have interpreted, this is not the case. It is wet ink. So it is not allowed. You cannot do an e-signature or any form of signature other than actually printed out and signed. There's nothing wrong with counterparts. So basically what that means is you could potentially have two originals, but provided that they've been printed and signed originally, it's okay. So that is allowed. But short of that, unfortunately, exchanges via email on digital signatures will not constitute a valid deed of sale. But obviously there is recent case law that doesn't really validate it. But there was a case that kind of threw a span into the works and confused things a little bit. And that's the one that Silna's going to chat about.
Perfect.
I love the term wet ink. And every time I read that and you read case law that refers to that, it always reminds me of like, it feels like that little ink pot with the pen with the feather. And that's how we need to sign stuff. Like, I want to be dramatic like that. I want a feather with like an ink pot and like,
you should get one for the office. That would be brilliant.
That's what I'm thinking.
You commission a document, you take out your feather and you start signing across the page.
That's amazing for dramatic effect. I would then just like an orchestra or something in the background, just like tum tum tum, and just like seriously make it like proper dramatic thing.
I don't know if you ever experienced this, completely off topic. There was a registrar in the Pretoria High Court that every time he was signing off court orders, he had this really weird signature. It was about half a page big. It was massive.
Yes.
It used to go all over the place, and it used to be scribbled up and down and then across a couple of times. And it took him really long. I mean, this was the longest he'd ever wait for a court order. But it was all over. It covered some of the words in the court order. Like, no one could fake it, granted. But it was just ridiculous.
I don't know. I must say, I can't remember that, but I've seen pretty interesting signatures in my life, I must say. But on the wet ink topic, the thing is, if the Alienation of Land Act requires signature in writing, it means wet ink. So what that means is with a pen on a paper. That is the best way I can dumb that one down. So the thing is, the case law that we have, and it's a very interesting article actually on it that was published by the property professional. I will find it sometime tonight if when Cyril is talking to us. I will find it and I'll share it onto the groups page as well. And so what happened in that particular case is the OTP was signed, so an offer to purchase signed through a DocuSign, so an online system where you can sign. But what's important to appreciate there is that system specifically timestamps your signature, and that's very relevant. And it does change it from a copy and paste on a PDF, because that's not timestamped and it's not, it can't be authenticated in any way. Where with DocuScan you can. And what happened in this particular matter, and the seller accepted, signed through DocuScan, and also so that the purchaser, and then the seller at a later stage accepted another higher offer, and the purchaser took the matter to court for specific performance, and they were successful with that. And the court's appreciation and position on that was actually that the intention of the seller was clearly to accept the offer. They can authenticate the signature and link it to the correct party. And at the same time, it's clear that the seller is trying to get out of the deal to obtain a higher purchase price. So like you rightly said, Bruno, it confuses the system, the situation a little bit, because the case law now seems to be like a clear, yes, offer to purchase can be signed digitally. And that is not the correct position. In this particular fact set, the purchaser was in a lucky spot. And so I would never, ever recommend that people bargain on that. But at the same time, because we have counterpart signature, that does make it easier. And during lockdown and stuff, I mean, people got very, very creative by signing in counterpart in different ways. You can print and you can sign and take a photo instead of a copy, and then at a later stage submit the actual original. So there are creative ways of getting around it. But I must say, Bruno, I've said that a few times about law, and you know, I say it about medicine in certain ways. These are two parts of society that still feels like it's just not keeping up with the times. If we're looking at some things that's happening in law and requirements in law, and I feel like, Yella, it's 2020. According to Back to the Future, we were supposed to fly around by now. We're not, yay, most of the time. But we need to get with the times, and I think that's something, legal development, that's really necessary. Absolutely. In a super urgent time frame.
Yeah, we should see it like in the next 50 years. It shouldn't. It'll be soon. 50 to 60 years. I'm sure the court systems will change and we'll start allowing things to be digitized.
Exactly, and then we're going to be older and wiser, Bruno, and we're going to be amazing practitioners.
Or dead, but it's okay, yeah.
No. Remember, I'm going to 120, so I'll come and tell the stories.
All right, thank you so much for that. I don't know if you guys have any last thoughts or anything to add.
Oh, no, I'm good.
Good. No, you're good.
I'm good as well.
I think that is about the time that we have then this evening. Thank you for all our viewers, and then we'll definitely see you next week, and enjoy the rest of your week. And thank you, Bruno and Silna, for joining me.
Well, thanks so much, Marty. Bye, guys.
Thank you.
Okay,
Bye-bye.
Bye.
Bye.